So, someone followed you for miles, brake checked you at 70 miles per hour. Maybe they swerved into your lane on purpose, and then there was a car accident. Well, that is not an accident. That is a deliberate act. And in Alabama, we treat such deliberate acts differently than mistakes. Today, I want to walk you through exactly how a road rage incident impacts your case, what legal tools are available to you, what you can do differently, and what mistakes could cost you everything. My name is Dee Asthana, managing partner at Caldwell, Wenzel, and Asthana, and we handle injury cases all across Alabama, Mississippi, and the Florida Panhandle. So let's get into it. Most car accidents involve negligence. That means the driver made a mistake. Maybe they didn't brake in time, they were following too close, or they were distracted. Negligence is carelessness, while road rage is completely different. Under Alabama law, there is a separate legal standard called wantonness, and it applies when someone acts with a conscious or reckless disregard for the safety of others. The driver does not have to be trying to hurt you, it's just that they're engaging in a behavior intentionally that they know could cause harm. For example, slamming on their brakes in front of you at highway speeds or chasing you off the road. Those are not careless mistakes, those are choices. Alabama Code 6-11-20 defines wantonness as the conscious doing of some act knowing that injury will likely result to another person. And courts have applied this to road rage cases, and that matters enormously for what you can recover. Here's why that distinction between negligence and wantonness matters so much for your case. In a standard car accident case, you can recover what's called compensatory damages. That includes your medical bills, your pain and suffering, your property damage, and your lost wages. It's designed to make you feel whole again. When wantonness is established, Alabama law allows the juries to award what's called punitive damages on top of the compensatory damages. Punitive damages are not about making you whole. They're about punishing the at fault driver's reckless conduct and to deter him and others from repeating that conduct. In cases of road rage with demonstrated evidence of aggression, the punitive damages amount can be very significant. And that changes everything in the way in which you negotiate your case with the insurance company because they're going to proceed to undervalue it. So now I'm going to tell you something that the insurance companies are going to use that is unique to Alabama. Alabama has one of the harshest contributory negligence rules than anywhere else in the country. If you're even 1% at fault in the crash, you may recover nothing. Insurance adjusters know this rule, and in cases involving road rage where the insurance company has exposure, they're going to do everything they can to find that 1% fault in your case. So the key takeaway here is that if the adjuster is arguing even 1% fault on your part, you need to remember that the at-fault driver engaged in road rage, which is the level of wantonness. And in Alabama, if the at-fault driver was wanton, the contributory negligence rule does not apply. Road rage cases live and die on evidence. Dashcam footage, witness statements, police reports, traffic camera recordings from nearby establishments, the other driver's cell phone records, social media posts, download of their black box. It can all be used to show that the at-fault driver's conduct was deliberate, not a mistake. Camera footage specifically can be overwritten in a matter of 24 hours, so it's extremely important that you call a personal injury attorney right away because that clock is ticking. So let me give you an example of how this can play out in a real case. A driver on Highway 98 in Daphne, Alabama, is repeatedly brake checked by an SUV over a merge dispute. On the third brake check, she can't stop in time and she rear ends that vehicle. The SUV driver tells the police officer that this lady causes the crash, and the SUV driver's insurance adjuster treats this lady who was brake checked as the at fault driver. But this lady made sure to get the contact information of a witness who saw every brake check. And a dash cam from a passing commercial truck captured what happened. This lady's personal injury attorney argues that the SUV driver engaged in wanton behavior. The fact that Our Lady rear ended that SUV doesn't define the case. The crux of the case is that that driver brake checked our client. One point to make here is that if our client did not have legal counsel, more than often that adjuster for the SUV would have offered her $0. In a nutshell, in a road rage case, if you are a victim and the at fault driver's insurance company is denying your claim, maybe they're saying that you were partially at fault, or they're saying that because that at fault driver was so intentionally reckless that there is no coverage for that driver, you need to call a lawyer right away. You have a case, and the lawyer will make that insurance company honor your claim. We at Caldwell, Wenzel, and Asthana hope that you're never a victim of road rage. But if that's your reality, we hope that you will give us a call today. We look forward to working for you.